Good morning. Hello. It's me, Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade, here with another exciting recap. This week was not an exciting week in the legal world, but I am here to touch on the major things that I found interesting. Good morning, Blue Nettie. Welcome. Thank you, everyone who's here. Woo. It is allergy season in Dallas right now. Woo-hoo-hoo. My eyes are itchy. My nose is leaking. I keep sneezing. So pardon me if I sniffle today. So ridiculous. I can't believe I subject myself to this crap. All right. Got my bottom grill. Now my teeth are looking nice. Again, if you need dental work or orthodontics in the DFW area, Studio Smiles is the place to go. So this week was relatively boring in the legal world, which is actually probably a good thing. Karen Reed's retrial is coming up, and she has a new attorney. She has several new attorneys. I'm not 100% sure. They have been arguing pretrial motions, and in particular motions to exclude experts. We'll watch some of it. Every time I watch, I'm like, this judge is insanely biased. Like, she asks the prosecution questions. She's really involved. She just kind of like doesn't listen to the defense, at least in my opinion. Hi, Marley. Yeah, listen. The dust in Dallas, there's like a huge dust storm. It was like, it's been so difficult to breathe in the last few days. All right, so this is Karen Reed's new defense attorney, and he's arguing a motion to exclude an expert. Okay, so the judge had just said something along the lines of like every defense attorney is liable for what other defense attorneys say. I guess one of the defense attorneys gave the judge information that wasn't like exactly correct. And so the judge was trying to say that every defense attorney is therefore liable, and he's like, no, it's not a strict liability.
.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't.
Can you guys hear that?
Know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law, the reason why knowing...
Okay, Mia, I don't know what's going on. Let's see if we can get it to work. Nope.
3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the
should be working now.
It's something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
Okay, so he's clarifying with her that he should not be liable for misstatements of other people on his team. He's true, he's right, unless they're, working together to conspire, which obviously they're not.
It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the deceased.
Okay, so the state is trying to put in a witness that's a expert on dog behavior to explain the dog bites on Karen Reed's deceased boyfriend. That whole time, the judge just let the defense talk. She never asked them a single question. She just listened.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by something.
This is such a weird setup that the prosecution's up here and the defense back here. It's very bizarre.
Shot object, is he? Are you planning on bringing her in?
I wouldn't ask him to do that, no.
All right, so I'll give you
Yeah.
Jim, yes.
Mr. Lisi tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case. And so, in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Lisi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive: variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Lisi is trying to bind the court regarding a comment of the necessity for a medical doctor.
All right. So they go on and on and on. The court's going to allow the doctor.
When his other text messages have come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me, is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety. I would submit at all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order. This communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then...
Okay, I guess they're trying to sanction him.
Ms. Brennan, you already had your concern?
I do have concerns about my ongoing obligations, so perhaps...
We did that because that was material that needed to be done.
Oh, I understand that.
I just want the record to be clear.
I understand. And I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that of, I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So, what was the date that Ms. Little made that statement, and what was the date that you were...
30th was the letter. We believe February 18th. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. So just in closing, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Okay, thank you. Any follow-ups from
The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
I may just briefly respond to it. I'd like the court to take particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Correct. He was not.
Motions that were really just filed. And what I'd like to do, I have one that has a response. So it's a motion to amend the scheduling order and the Commonwealth's opposition. I would like to hear that now. I need to give them a minute.
Okay, so it's exceedingly boring. Exceedingly boring. Good morning, Tall Glass. Thank you for joining us. I just don't think that Karen Reed is getting a fair trial. I think the judge's conduct in her first trial shows you that this judge is not giving her a fair trial. That's from outside observer. I don't know. I'm not in the courtroom every day. I don't know anything about that judge. Okay, so if y'all recall, Tony Busby had a 13-year-old, a client who was 13 at the time of the incident, who sued Diddy. Then she added Jay-Z to the suit. Then Jay-Z's lawyers came after Busby. Then Busby dropped Jay-Z's suit. And now Jay-Z is suing the accuser.
Firing back, the rap mogul is suing the woman who claimed he raped her, and he's also suing two of her lawyers just weeks after she dropped her lawsuit against him and Sean Combs.
Okay, so he's definitely coming at them. There was no waiver, no release signed, obviously.
Claims. She said she went to the VMAs at Radio City Music Hall back in 2000 when she was just 13. Her lawsuit claimed one of the limousine drivers she spoke to claimed to work for defendant Combs. The driver told her that Combs liked younger girls and said she fit what Diddy was looking for. And while not allowing her into the awards, the driver invited her to an after party. The driver stated that he had to drive Combs and others to the after party first, but instructed plaintiff to return to his location after the event and that he pick her up and take her to the after party. Jane Doe's suit described her being driven to a large white house with a gated U-shaped driveway where she saw and spoke with other celebrities and drank something that made her feel woozy and eventually made her way to a room where there was a bed. The suit stated, soon after, father picking her up. The suit states, regarding her long pre-dawn drive home with her father, Doe's father told NBC News that he does not recall picking up Doe, which unsurprisingly would have been something that would definitely stick in my mind. He said that he learned of the alleged assault when Doe was interviewed by NBC News in December, and that he did remember once picking Doe up in the middle of the night, but it was a local drive. Based on their address in Rochester, New York, Doe's father would have driven at least 5 hours and 47 minutes to pick her up. And Jazy-Z says just last week, Jane Doe admitted to his reps that the story she told wasn't true. The suit states, Doe has now voluntarily admitted directly to representatives of Mr. Carter that the story brought before the world in court and on global television was just that, a false, malicious story. She has admitted that Mr. Carter did not assault her, and that indeed it was Busby himself, whom she met for the first time at a coffee shop in Houston on the day of her maliciously false NBC News interview, which is discussed in detail below, who pushed her to go forward with the false narrative of the assault by Mr. Carter.
Ooh. Ooh. If this is true, that is really bad for Tony Busby. That is a violation of ethical rules. It's a violation of the law. That is really bad. So if Jay-Z's attorneys can prove this, Tony Busby is going to be in a lot of trouble.
To leverage a max.
A lot of trouble. Okay, so it's been a pretty slow week trial-wise, but Boleyn found this very interesting story. Oh, here comes the sneeze. Hold on, guys. No. Okay. Boleyn found this very interesting story. I can't remember. I think it's out of like Ohio area. I know for sure it's near the Amish. And this man's name is John Skelton, Skelton. So basically, John was not seeing his kids because he was, I don't know, threat to them. And his soon-to-be ex-wife allowed him to take the kids on Thanksgiving, but then they never came home. And that was 14 years ago. So Skelton is in prison for kidnapping, but he has never said where the kids are. I think now the wife is trying to go have the children declared deceased, but it's hard to do because there's no body. Like, he just took the kids. So let's see what Vinny, I don't know how to say his name now, Vinny Napatoli, whatever his name is, Vinny Politan investigates. Let's see what he has to say.
Fall of 2010. Their mother, Tanya Zuvers, had custody, but the boys were visiting with their father, John Skelton, for Thanksgiving. Tanya was supposed to get the boys back on Black Friday. She tried calling John, but could not track him down. So she drove to John's house. No one was there. John was at the hospital being treated for an injured ankle, but did not tell her where the boys were. Tanya called police, and an Amber Alert was issued. When police searched John's house, they found it destroyed inside. When questioned, John gave varying stories about where the boys were. John was prosecuted for charges related to the boys, but not homicide. And he has now served more than a decade in prison and will be released in 2025. Their mother has gone to court trying to get the boys declared dead. Meanwhile, Tanner, Alexander, and Andrew are still missing.
All three boys.
Afternoon, wanted to know if I could pick the boys up earlier than the 3 o'clock. He said, well, we're not home right now. We went to my friend's house. We're north of Jackson. I don't know when we'll be home. I said, well, just keep in touch with me and let me know. And so we left it at that. Well, then I saw movement at his house. And
now, let me stop you for a second. You say you saw,
I saw movement out my kitchen window.
So where you were staying?
Where I was staying, between the neighbor's tree and house and across the empty lot, I could see his driveway.
Okay.
I saw a vehicle pull in his house, and I saw 2 people come out and get in the car and leave. And that's kind of weird. So I messaged him. I'm like, hey, are you home? And he's like, no. And then that's when he tells me that, oh, actually, the boys aren't with me. I was home. The boys are with my friend. She's bringing them home at 3 o'clock. I'm on my way because I fell off the ladder. I'm going to the hospital. I don't know. I hurt my foot.
So, 3 o'clock.
Okay. So the judge did on Wednesday declare that the boys are deceased. This is her testimony talking about what happened that day. So let's get into what happened potentially that day.
For that portion of the Thanksgiving break, and there's a flurry of activity. But one of those activities is not the kids being returned to her on that day as scheduled, as planned.
Yeah, Phil, you're just looking initially at what we're talking about here, which is the stories that are taking place from the father, but also the place where they were staying is a complete mess. And the boys are nowhere to be found. To me, that's huge red flag and crucial evidence in all this.
Well, of course it is. Good to be back with you, Nick. Good to be back with you, Vinny. You know, what's interesting about what she testified to, what I picked up on, was that she says she saw 2 individuals get into the truck. So my curiosity was immediately piqued as who's the other individual? Was that person interviewed at the first part of this investigation, or is he an unknown and remains that way? In regards to the condition of the house, it would tend to lead me to think that he had done what he had done in the house, and that's a result of the struggle. That's a result of just him going completely off, and in that place and time, that's where he may have murdered the boys. He's maybe got 3 individuals here. I mean, I know they're little guys, but you still got to keep those people, keep them under control.
So basically, the kids went to Thanksgiving with Dad and never came home. Then the dad, John Skelton, had like a ton of different stories he told. Like, he said he left the kids with the Amish. He said some other things, like just other stories. So the twist in this, and I think maybe why it's taken so long for anyone to do anything, is that the mother had been charged and found guilty of taking advantage of a 14-year-old boy. And so there was already like this suspicion about her, because now she has sons, and she was 32 and she hooked up with a 14-year-old, which is totally unacceptable. And so I think, part of me thinks maybe the reason the investigation wasn't taken as seriously, or they didn't automatically consider it, instead of just a disappearance, like a potential that these children were harmed, is possibly because of who the mom was and what her background is.
Schoolhouse near Kunkel, Ohio.
A team was dispatched to search any schoolhouse in Kunkel, Ohio. Is that what you're saying?
Well, he said an old schoolhouse, so we identified those 2 locations as being really the only old 2 schoolhouses, and we checked them.
And what'd you find?
Nothing. Came back from our searches. They went back in and spoke with him again. During this time, John described having a nightmare, and within this nightmare, he describes what he thinks is Joanne Taylor, but he's unsure if it was possibly himself. And he explains that he is, I believe, is it 95% sure that the boys were in a dumpster near Holiday City, Ohio. He urges the interviewers to respond and get his boys.
He had a dream, huh? He had a dream that that's where they were. Yeah, so I'm thinking he had like a blackout rage, did something to the kids, dumped their bodies later.
To himself, that he refers to himself being perceived as a monster. He expresses concern about being perceived as a child killer during the course of this interview.
And this is also when he says that he may be Joanne Taylor.
Yes, he was unsure, as he described.
Okay, Phil, what does your gut tell you about these first 2 stories? Is there any chance that there are pieces of the truth hidden in there, or are they just...
Yeah, pieces of the truth hidden in there. He's confessing, basically.
Move the kids to a secret organization. What he described was that he was at a truck stop near Niles, Michigan. He was eating in the restaurant, struck up some conversation with a guy there, and out of that conversation, the guy indicated that he had connections to a secret organization that could facilitate moving the kids safely. Not long after that...
Oh yeah, that sounds very likely. You're at a diner and someone's like, oh, I have a secret organization, we can move your kids. And you're like, oh yeah, okay. Like, come on.
Conversation, John said that he began receiving nondescript envelopes in the mail with instructions and paperwork regarding this organization, and a cell phone with a pre-programmed phone number in it. When the interviewers attempted to seek verification and can you provide any of that documentation or anything, he explained that the instructions were to burn materials and or return the other items that weren't burnt. And this exchange apparently went on for
Isn't that convenient?
period of time until the boys were turned over to this organization he identified as United Foster Outreach and Underground Sanctuaries.
Nick Edwards.
So clearly, the guy
Specific
keeps
names, United
changing
Fosters Outreach.
his story. He kept moving the goalpost. Obviously, you know, there's evidence in that house that something happened, some kind of fight or something. So the reason the mom now, 14 years later, is wanting her children to be declared deceased is then, and only then, is my understanding of the law of their state, is that then they can pursue the murder charges for the children. So she's pretty hell-bent on that, as would I be. My daughter was sick yesterday, so she watched Kill Bill Volume 1 and 2. I told her, this is what I would like to think I would do if somebody harmed you. Learn how to be a ninja and enact my revenge. So yeah, parents don't just like send their kids off to secret organizations. Like, that didn't happen. The dude is full of shit. Okay, so speaking of people who are full of shit, I am going to be going to the Diddy trial. It starts on May 5th in New York, in Manhattan. And I will begin organizing, and maybe I'll think about it today, a meet and greet in New York for those of you who are interested, who are in the Yankee land, who are nearby, who can come. I think that would be really fun. Hey, Brownie, good to see you. All right, y'all, that is really the entirety of my recap today. It's been a pretty light week in the law. I will be in New York May 5th for the Diddy trial, so if you're interested, please get yourself a hotel. Let's do a meet and greet. We'll probably do a meet and greet on the 6th. So, write it down. Thank you for being here. Thank you so much for your likes and your subscribes. It's wonderful. Your support is amazing. Thank you to my members. I appreciate you, and I will get you some extra member content soon. My daughter's going to dye my roots this weekend, so maybe next week. All right, y'all. Thank you so much. See you next week.